In most of the modern world, the idea of punishing a crime with a whip or a cane sounds like something from centuries past. But judicial corporal punishment, the use of physical force ordered by a court, is still alive today. While more than 130 countries have banned it, some nations continue to sentence offenders to public or private beatings with sticks, whips, or other implements of pain. In this video, we examine how judicial corporal punishment works, where it's still used, and why it remains so deeply rooted in certain legal systems. What is judicial corporal punishment? Judicial corporal punishment refers to the use of physical punishment as part of a legal sentence handed down by a court. This includes caning, whipping, flogging, strapping, birching, bastinado, beating the soles of the feet, and in some extreme cases, amputations. Unlike spontaneous violence or domestic discipline, judicial corporal punishment is formalized, often with strict guidelines. Number of strokes, target area, gender, and sometimes even the size of the implement are specified. It's important to distinguish judicial corporal punishment from corporal punishment in schools or the home. Judicial corporal punishment is a state-sanctioned, legally approved act carried out by trained officials, often behind closed doors, but sometimes publicly for the sake of deterrence. Which countries still use judicial corporal punishment? Today, judicial corporal punishment is rare globally, but it remains legal and practiced in about 30 countries. These include a mix of Muslim-majority countries, former British colonies, and small island nations. In countries like Singapore, Malaysia, and Brunei, caning is a formal part of the legal system. In Singapore, caning is used for a wide range of crimes, including vandalism, drug trafficking, and immigration violations. The Michael Fay case in 1994, where an American teenager was caned for vandalism, brought global attention to this practice. In Saudi Arabia, Iran, and Qatar, judicial corporal punishment includes flogging, lashing, and in some cases amputations, often justified under Sharia law. Crimes such as theft, adultery, or moral offenses can result in public beatings. Nigeria's northern states, operating under Islamic law, still enforce whipping and caning, sometimes even in public squares. Indonesia's Aceh province is another example, where men and women, primarily Muslims, are flogged for offenses like drinking alcohol or being alone with someone of the opposite sex. How is the punishment carried out? The methods vary widely by country and legal code. In Singapore, male offenders are caned on the bare buttocks with a heavy rattan cane. The strokes are spaced out, each delivered with full force by a trained officer. The punishment often causes deep welts, bleeding, and permanent scars. Medical staff are present to ensure the offender is fit to be caned. In Iran, flogging can be applied with a whip or strap, and the number of lashes can range from 10 to 100 or more. While some are done in private, others are public, carried out in courtyards or even in marketplaces. Offenders may be forced to stand or lie down, and sometimes tied to a post. Malaysia differentiates between criminal and Sharia law. Under criminal law, men are caned with the rattan cane in private. Under Sharia law, both men and women can receive light caning on the back in a courtroom setting. The method of application, clothed or bare, public or private, gender-based distinctions, is tightly controlled, but the impact is severe in almost all cases. What is the historical background of judicial corporal punishment? Corporal punishment by courts is not a new concept. In ancient Egypt, thieves might be flogged or have their noses cut off. In the Roman Empire, scourging was a common punishment for both criminals and slaves. In medieval Europe, judicial beatings were routine. In many British colonies, judicial caning and whipping were formalized by the legal system and passed down through centuries. Countries like Barbados, Botswana, and Tonga inherited this model and still have laws permitting caning or birching today, especially for male offenders. In the United States, judicial corporal punishment was phased out by the 20th century, but whipping posts remained in use in Delaware until 1952. In fact, the state only removed the whipping post from its criminal code in 1972. In South Africa, judicial corporal punishment was abolished in 1997 after the Constitutional Court ruled that caning of juveniles violated human rights. Similarly, the United Kingdom formally ended judicial corporal punishment in 1948, though its use in prisons persisted until 1967. Where are amputations still legal? While flogging and caning are most common, some countries retain even more extreme corporal punishments. In Iran, Saudi Arabia, and Afghanistan, amputations can be sentenced for crimes like theft or highway robbery. Although less frequently carried out, these punishments are technically legal and sometimes enforced, particularly in regions under stricter interpretations of Islamic law. Under the eye for an eye philosophy, Iran has occasionally sentenced acid attackers to be blinded in retribution. These cases spark international outrage and human rights criticism, but they underscore how judicial punishment can go far beyond mere beatings. Do gender and age affect sentencing? In many countries, only men or boys are subject to judicial corporal punishment. In Singapore, only males under the age of 50 can be caned. Women are exempt under the law. In Botswana and Swaziland, judicial corporal punishment is only used on boys and men. This gender divide reflects older views about masculinity, punishment, and physical endurance. However, in countries like Iran, Afghanistan, and Indonesia, both men and women can be whipped, although the exact procedure might differ. In some conservative regions, women are flogged behind closed doors or while covered. Children may also be subject to corporal punishment in certain contexts, especially in countries where there is no separate juvenile justice system. What are the arguments for and against judicial corporal punishment? Supporters of judicial corporal punishment argue that it acts as a strong deterrent, especially in societies where prison systems are overcrowded or underfunded. Caning or flogging, they claim, is quick, low cost, and highly effective in preventing repeat offenses. Some governments also defend the practice on religious or cultural grounds. Opponents, however, argue that it violates basic human rights. Organizations like Amnesty International and Human Rights Watch call corporal punishment a form of torture. Medical experts say the psychological trauma can be long-lasting, especially for young offenders. Critics also argue that it is often applied unequally, targeting minorities, the poor, or political dissidents. Has international pressure changed anything? In recent decades, international bodies such as the United Nations Committee Against Torture have called for the abolition of all forms of judicial corporal punishment. Treaties like the Convention Against Torture and the Convention on the Rights of the Child urge member states to eliminate physical punishment from all legal systems. Countries like South Africa, Jamaica, and Kenya have abolished judicial corporal punishment following internal legal reforms or international pressure. The European Court of Human Rights ruled in 1978 that judicial birching was degrading and violated Article 3 of the European Convention on Human Rights. That ruling played a key role in ending birching in the Isle of Man, Jersey, and Guernsey. Despite these pressures, some governments remain defiant. In Brunei, Saudi Arabia, and Singapore, authorities maintain that judicial corporal punishment reflects local values and should not be subject to foreign influence. What do you think about judicial corporal punishment? Share your thoughts in the comments below. If you'd like to learn more about punishment worldwide and throughout the ages, don't forget to like and subscribe for more videos.